Marco Mendicino is Canada's Minister of Public Safety. He joins me now. Minister Mendicino, good to see you again. Thanks for taking time to speak with me tonight.
Thank you for having me.
Look, to be clear, you had no option under the law except to follow through with this public inquiry. It forms a part of the Act as a follow-up whenever it's invoked. So let me start with the role of Justice Rouleau. Will he be allowed to pass judgment on whether the decision to invoke the Act was warranted or not? Will he be allowed to say whether you were justified or whether you went too far?
I mean, I think the short answer is yes. We have embarked on a full-blown public inquiry under the Order in Council, which came into effect today, which was a way for us to foster more independence, more transparency, and more accountability to look precisely at the question which you posed, which is whether or not those circumstances were sufficient to meet the test as articulated under the Emergencies Act. From where we sit, we think it was important to have chosen this particular legislative method of a public inquiry, which affords Justice Rouleau, a very experienced jurist who sat on trial courts and appeal courts, with the capacity to compel people and documents and information, including some classified information, so that he can have a full record and access to the information that he needs to make that determination, but equally to perhaps put forward some recommendations so that in the face of another public order emergency of this variety, we don't have to invoke again, and we're not in the same kind of situation.
Let me pick up on that. When you say we felt we were justified, you're speaking of yourself as part of the government and presumably your cabinet colleagues. And so to be able to reach his conclusions, one of the things he'll have to do is have access to documents, some of them, many of them classified. And I guess let's go there. Will he have access to all the documents that were part of the government's consideration in deciding to invoke the Act? Because I think that's what Canadians want to know. What evidence, what debates, what conversations did you have that led you to invoke the Act?
Well, I think the first thing I would say is that it's the government's intention to cooperate with the commissioner and the public inquiry to ensure that he has access to the information that he needs to fulfill his mandate, which allows him latitude to look into things like the ideological core of the movement, the funding that aided and abetted it, the impact on the economy and public safety. And I think when it comes to classified documents, you're right to underline that there may be some issues that are implicated around cabinet confidence, but let's cross that bridge when we come to it. And ultimately, those will be decisions and processes that will be undertaken in the independence of and the fullness of time under this inquiry.
Okay, so to be clear, what you're saying is there will not be a blanket waiving of cabinet confidence. You're saying you will make decisions based on case by case, which documents he's asking for or believes he needs, and whether you believe you can release them.
Correct. Yeah. No. I think you've sort of succinctly summarized our position, which is we don't want to usurp or be presumptuous around what information Judge Rouleau will ask for access to. We want to allow that process to unfold. Again, in keeping with the Order in Council, we have afforded him broad powers around people, around documents, information. And of course, as I said earlier, we do contemplate that there will be some sensitive and classified information, which he may need access to do his job. Our intent is to be cooperative with the commissioner.
Right. So do you foresee any occasions where Justice Rouleau will be asking for documents from your government and he'll be told by your government he can't have them?
Well, again, I think it's important not to get ahead of our skis on this. I think what is important is that the judge has the powers to compel information that he needs to do the job. If it does happen to implicate a cabinet confidence privilege, which, as you know, exists for the purpose of allowing cabinet to have a robust debate and exchange of ideas around sensitive decisions. For example, the invocation of the Emergencies Act for the first time, that it has the space to take those decisions and to be able to reconcile those constitutional principles with the mandate which he has been given. And in order to be able to do that independently, we want to allow him the space to undertake that work.
Right. And I've got the Order in Council here with me. And in it, Justice Rouleau is also being asked to look at what might be needed to modernize the Act. Will you commit to that any recommendations he makes about modernizing the Act that you'll follow, they'll be binding?
Well, as I said earlier today, we've got a strong track record of working with independent public office holders who provide reports and recommendations to the government. This will be no different. Any recommendation that Judge Rouleau puts forward that may revisit some of the questions around jurisdiction, around law enforcement powers, be they existing or perhaps new tools, are recommendations that we will take very much under serious consideration. As I said, Judge Rouleau has a plethora of experience before the courts, both trial and the appellate level, and he understands, the significance of the task that has been given to him, which is why we're grateful for his work and all that's coming, including putting forward some ideas, some suggestions, some recommendations, so this kind of thing never happens again.
The Order in Council also calls on Justice Rouleau to ensure that no information he acquires that could hurt national security, national defense, or international relations be released to anyone but the Government of Canada. Will that decision of what he thinks might be injurious to any of those areas I've listed, will that decision be left to him or to the government?
Well, the Order in Council, which you just cited, does repose in him the power to make some determinations around what is and what is not injurious. We anticipate that if there are classified information or other things which he may want access to, that he will be able to reconcile those principles, again, with the mandate and the parameters of the public inquiry, something that he is very experienced at doing as a sitting jurist. And I would just point out, again, that the reason for these principles, particularly around not disclosing into the public domain those things which could harm Canadian interests, be they domestic or foreign, are to ensure that we can keep Canadians healthy and safe. And so being somebody who sits on the bench and has sat on the bench for many years, he would be familiar with the balancing exercise, the legal analysis that goes into those decisions. He would be aware that there needs to be engagement with government and the appropriate branches who are implicated in those decisions and who are the guardians of that information. And we have full faith and confidence in his ability to discharge those responsibilities.
All right, Canada's Minister of Public Safety, Marco Mendicino. Thanks for your time tonight, Minister. Appreciate it.
Thank you very much.